But I appear in transferred case 12 of 2023, Zainab Patel versus Union of India. Your Lordship may, my Lord, for the time being, not take the note originally filed because coming as I do in the middle order, I had one distinct advantage, my Lord, to follow the deliberations, particularly the queries of Your Lordship, the responses of the Union, and the note submitted today, my Lord, encompasses and tries to answer some or all of the questions that Your Lordships have posed, my Lord, and my learned friends preceding me, my Lord, who have done a very able job, have raised in the matter, my Lord.
Mr. Vishwanathan, if you could just assist us with the formulation.
I will just formulate it, my Lord. Just give me, I have, my Lord, a written note with an index, but I just want to give Your Lordship a prefatory note. I'll take 3 minutes of my own time on that, my Lord. My Lord, at the bottom of all these constitutional questions, which I have set out and answered, is the one plea of the petitioners before Your Lordships here. And to simplify it, it is just this, that if we can be, my Lord, sons, daughters, brothers, sisters, brothers-in-law, sisters-in-law, uncles, aunts, friends, and partners after Your Lordship's judgment, what is it that holds back from giving us that status of a married spouse, which we, my Lord, acquire and seek to acquire for ourselves and seek recognition from the union, which union has, my Lord, wholeheartedly provided it for the heterosexual couples? The only answer is your sexual orientation, which is, my Lord, beyond my control, and the fact that marriage as an institution, as they and the majority of the heterosexuals understand, does not comport with your practices, your requirements. Hence, we would not admit you to the institution of marriage and accord you the privileges which we wholeheartedly, willingly, by enacting a legislation, accorded, my Lord, to heterosexual couples. Does that have constitutional sanction? The second answer they give is, by your very nature, you cannot procreate. If so, my Lord, I have dealt with in my note, is procreation a valid defense for negating, my Lord, the rights of recognition of marriage? And, my Lord, if we ponder deeply, which has been developed in the note,
Thanks.
which has been developed, my Lord, procreation or inability, my Lord, to procreate is no answer. None of the marriage statutes, my Lord, prescribe any upper limit for marriage. Even today, people who are, my Lord, beyond the age of, my Lord, reproductive capacity, women beyond 45 who medically may be unsafe for pregnancy are allowed to marry. There is nothing obnoxious about it. People who have decided not to have children, who cannot have children, heterosexual couples, are allowed to marry. Well, these are well settled. So, my Lord, procreation is no answer. Then, my Lord, does it not bring back the arguments of the miscegenation statutes, my Lord, of which I have made reference? Arguments are very similar. The judgments before Loving versus Virginia, the holdings are very similar, my Lord. Even the trial court holding in Loving was on the basis that it doesn't accord with our religious beliefs and the common notions of marriage. So we won't permit you to marry. But Loving said no. Because, my Lord, it said you cannot understand marriage with any traditional notion that you may have. The other fallacy in the argument, my Lord, is again relatable to a historical fact. My Lord, these are moments in history, my Lord, which we are passing. Similar instances have happened before. All that the union is saying is, everything else is fine. All other relationships are fine. You are almost equal, but you are separate. This is exactly, my Lord, what was the stand in Plessy versus Ferguson.
Exactly.
I have placed passages from Plessy, except that there it was separate but equal when they segregated the classes. Here it is separate but almost equal but separate. Don't come into the institution of marriage. We will see, my lord, the arguments of the state in Plessy very briefly and the holdings in Plessy. And we will also pay a tribute to Justice Harlan, who dissented in 1895, which got, my lord, reinforced in Brown.
Brown ultimately.
Board of Education. And also, my lord, in Loving versus Virginia on the miscegenation aspect, my lord, as to how these very arguments advance with great fervor. That look, this doesn't accord with my belief that it has to be a certain order because it has gone on for centuries. So in that sense, my lord, this is a moment of history which your lordships, my lord, are passing through, which we are passing through, my lord. And my lord, what your lordships are going to lay down is going to have, my lord, an important repercussions for the future. Then the further question, my lord, which has been considerably debated, which has been addressed is, do we look at it from the prism of the statute, or do we start with the prism of fundamental rights, my lord? Because if your lordships found that our claim for the union of marriage, which is the ultimate union in any, my lord, partnership, procreation and mating, my lord, are incidental consequences. If any of us here, my lord, most of us heterosexuals were to be told that what is marriage after all, it is meeting and mating of a youth and a damsel, my lord, we will laugh at the gentleman. It is certainly not that. It may be an incidental part of it. But there are much greater things in a marriage. There is, my lord, coming together of two souls. It is even addressed as, my lord, my lord, an institution which addresses the ego of the individual, where there is understanding. It helps in developing the human personality, a happy marriage. So, my lord, to be told that, my lord, it has to be looked at from the procreation perspective is completely fallacious. Special Marriage Act, my lord, is a secular law. Bommai has reiterated that before the 42nd Amendment, secularism was implicit in the Constitution. If a law like the Special Marriage Act were not to be enacted, my lord, imagine a scenario. Your lordship would have found it a positive obligation in commanding the state to enact it, just as they would not be able to repeal it today, my lord. Assume a state, my lord, to cut the notes wants to spite the face. So, my lord, we need to look at it from the constitutional perspective. The acts will have to be tailored. If there is a right, my lord, which is a fundamental right, it may fit into the statute as it now stands. It may have to be, as Fowry said, to be tailored, to be brought in line. Your lordship may give directives. Let us not forget, my lord, we have challenged the validity of the act. It is in the process of saving the act that your lordship are resorting to these devices. The consequence would be that the act would be struck down and they would be asked to legislate, because it will be a positive obligation in a secular country like ours that you can't leave marriage between people who don't want to go the religious route to be unregulated. There is to be streamlined.
You actually sought for that as the first relief.
We have, my lord, in 3 petitions, direct declarations that the statute, which only recognizes heterosexual union, if it is to be so construed, is invalid. My petition seeks a declaration. Honestly, an amendment was drafted, but Zainab is not well to execute that affidavit. But, my lord, that is taken care of in Ms. Grover's petition and 2 other petitions. So, in the exercise of trying to save the statute, any guideline your lordship gives, it's far different, my lord, from saying that court is being asked to legislate. Court is making an effort to save the statute in this process, my lord. So, it will not be a legislative exercise, nor can we be told that these are measures which you have to await for Parliament to enact. The century has told us, my lord, that we have no admission to the institution of marriage. We have now come to the sentinel on the Kavi for the same relief. And we are founding it on constitutional grounds. My lord, then the aspect of transgender, because even, my lord, in transgender persons, the 3 categories, the male manifested gender, the female manifested gender, they are entitled to maintain that manifestation. And, my lord, the trans person who doesn't manifest any gender, third gender, are inter se, my lord, between them. A male to a male is entitled to marry, a female to a female is entitled to marry, a trans person and a trans person is entitled to marry. NALSA, my lord, expressly guarantees a right to marry. The union may say it was in 2014 before the act and in the sense of a heterosexual marriage between a trans man and a trans woman. But today, my lord, this issue and the transgender case also, my lord, involves when you say that you are as good as any other citizen and we don't discriminate. This aspect can't be held back only because of an aspect which is nothing attributable to my fault. It is an aspect of nature. Just as you have right-handers, you have left-handers too. Just as, my lord, you have heterosexual people, there are homosexual people who have come out. It is widely, my lord, an accepted nature all over the country. It is not confined to urban, my lord, situation. As your lordship, my lord, the Chief Justice said, maybe in urban areas, my lord, they have been more emboldened to come out and, my lord, seek their reliefs. Lastly, my lord, the note addresses the molding of relief. And, my lord, I have respectfully placed two scenarios, the Fowry scenario, where to save my lord, the statute, they gave an option to amend, which they may resort to, my lord, and streamline the statute. There is another scenario, my lord, where all that is required is to read the word spouse by equalizing it, my lord, and I have placed case law for that, where you equalize them, give them that status, so that, my lord, they are on par. They proceed with their own way. My lord, it infringes nobody else's right if two people get married of the same sex.
So,
So
Mr. Vishwanathan,
Yes.
sorry to interrupt you, but just a clarification. Since you mentioned that though there is a relief by virtue of a declaration sought by you and in Vrinda's case, you're willing to go the point of a guideline being laid by court as was being argued by your predecessor.
To save the statute, my lord. Nobody wants a scenario where the act is stuck down lock, stock and barrel, because that is the other consequence of it. So the inquiry is not that, can we do all this, can we read it? Your lordship are reading it in to save the statute, not, my lord, so that it is not struck down. I go a step further. Today, it cannot be a scenario where the Special Marriage Act is not even enacted. Assume, my lord, today there is
Your
no act.
point is non-recognition would itself be an act of constitutionality,
Constitutionality.
and therefore to save it, you read the statute so as to bring recognition
That is
both to
that.
heterosexual and
My lord, this is, my lord, this will, my lord, give us dignity, give us equality, ensure that message goes from your lordship that we are not looked upon as Justice Albi Sachs said, as an oddity, as an outsider, as some anathema, my lord, to society, some alien, so that, my lord, we get our respect. And once your lordship pronounced, like in Johar, and my lord made that point on the first day, it percolates down to the society, my lord. There is acceptability. Court has said so. My lord, our society is a law-abiding society, my lord. They'll know, oh, this is a point of view, and your lordship reason it out, and that reason percolates. That's how it is accepted, my lord. Today, why is basic structure, my lord, accepted? It is founded on a sound reasoning, my lord. It's 50, 60 years now. Nobody has been able to dislodge it because your lordship's institution gave sound reasoning to it. So all that is required is a message from your lordship, assuming your lordship accept it. In this, my lord, background, just see, my lord, my note. My lord. I will now, my lord, I've extracted most of the paragraphs so that reference to the volumes, my lord. I just want to, my lord.
Then I think you've covered it very comprehensively in what you said. You were
I just
curiously typing away when you were arguing. So I think
I just want to, my lord, since something has been put down, use the time that your lordship gave. My lord, when there was a grim scenario when your lordship debated the time, I wanted to mention, your lordship recollects the 4th book of David Panic.
yes.
I have to move my car. It came this way. The US judge asked the lawyer, how long are you going to take? He said, don't worry, you are not. I have to move my car because in US, after 20 minutes, he'll be charged for parking. Now, the only reason I didn't say that was, your lordship should not now charge us for parking. That will be a way, my lord, where we cut down our time.
Thanks for the idea.
Someone else pays. Someone else pays for it.
But my lord, the book is titled A Collection of Articles published by Dr. David Panic in The Guardian. is collected and beautifully written short pieces.
That's
I had to move my car.
Who moved my car?
The
I moved my
judges,
car.
the earlier one was judges.
Judges and advocates.
My car is a beautiful.
Very, very delightful read.
I haven't.
Speaks about a tourist guide.
By 10th to me, Beautiful.
Speaks about a tourist guy walking past his office. Make the best use of my time. My lord has the note called, my lord, loaded
Yes.
today. My lord, we are not
The
sure whether it will be
nominative
loaded.
Marriage and choice
Yes.
begins with that.
My lord, that only one line from that,
No, which note are we looking at?
that kindly come to my lord Carlos Ball. Sorry, my lord. My lord, we have, my lord, I know your lordship detest hard copies. I have a soft copy, but I also, my lord,
I have a soft copy.
Very good.
First one, Carlos,
just see page 4, my lord,
Page
Carlos
one.
Ball.
Carlos Abol, rest, got it.
Yeah.
Not this one, not.
My lord, may I give a hard copy to you?
Something from what was earlier.
Yes, my lord. My lord, after your lordship's queries,
Yes, right.
One Goodrich versus
a
department.
Goodrich versus department, my lord, some of them are culled out from cases cited in Fowry. Some independently, my lord, my team has, my lord, been able to collect.
First 10 to 12 pages you have covered as to the meaning of marriage.
Yes, my lord. On marriage and how, my lord, it is.
Quoted Martha Nussbaum also.
Martha Nussbaum is quoted, my lord. A learned friend, one of them was very exercised, my lord, leading and a treatise already quoted by your lordships in Navtej.
Yes.
I will, my lord, very selectively read so that my learned friends are not hard pressed for their time. But I'll make the use of my time. Yes, my lord.
This is after volume 4.
This is compiled.
While our
One second.
application-
Mark it. I'm not going to read it. Page 4,
That quotation,
Carlos,
yeah.
Morality of Gay Rights, Carlos Ball, on how, my lord, constitutive elements of personhood get its full blossoming when the marital union, my lord. As your lordship come down the italicized portion, page 4, my lord. The
Yes.
public recognition, when it is accompanied by social support and encouragement, makes it more likely that the relevant responsibilities will be met. The structure that marriage provides, the obligation that it requires, then can strengthen and make more durable the affectional components of sexual intimacy that are characterized by ongoing commitment and mutuality. The socially recognized marriage relationship can provide the structure through which the well-being of the partner becomes inextricably linked to the well-being of the self. Fundamental to it, my lord, is the choice, as my lord, my learned friend Ms. Tara, my lord, wants me to emphasize. The aspect of choice put in bold letters, my lord, through the first 4 paragraphs.
Yes.
My lord, Goodrich said, yearning for security, safe haven, and connection has expressed that express our common humanity. My lord, this is to remove it far away from, my lord, the procreation part which was highlighted. My lord, kindly come over the page on the aspect of, my lord, the equality code, how only one form cannot be determinative. My lord, Fowry, one important passage Dr. Singhvi placed in his note, my lord, but just see the para 13 before the extract, my lord. The South African Constitutional Code felicitously explained that equality does not imply the leveling or homogenization of behavior, but rather it lies at its core in the acknowledgement and acceptance of difference. The court further explained that equality requires persons to be able to accommodate the expression of what is discomfiting.
What like free speech?
Yeah.
Yes, my lord. My lord, kindly mark PDF 2044, my lord, there. In case I have just marked it, but I am not, my lord, going there to read it because these are words from the judgment. PDF 2044, volume 4 of the case law compilation. It is humbly submitted that the petitioner's case before the Honorable Court requires a similar conception of equality. The efforts made herein are for social acceptance and for the citizenry to ultimately acknowledge and accept the difference and to accommodate for the existence of the LGBTQIA plus persons in the same way in which heterosexuals lead their lives. the interests of the heterosexual persons and the LGBT persons do not collide. They coexist in a constitutional realm based on the accommodation of diversity. My lord, that is PDF 2068. My lord, over the page 8, para 16, only because the union says we have prescribed age restrictions, we have prescribed prohibited degree. But they are founded, my lord, on solid, my lord, grounds of health. Kindly see, my lord, how we have addressed it from line about 4 in para 16. In this regard, it is submitted the same is a defense which is the nature of purported facial equality and ought not to be accepted by this court, whereas the restriction of certain class of heterosexual persons from being married, such as minors or other forms of prohibited relationship, directly relate to the state's power to restrict the said marriage on the grounds of either health or such other acceptable grounds. My lord, much was debated on how to apply part 1, part 2, will it be reading in, etc. My lord, till the legislations are streamlined, there is a principle of rule of interpretation. Principles analogous thereto will apply, my lord. Your lordships have extended it in the Limitation Act for courts and tribunals. So apply principles analogous thereto till such time the legislature is streamlined. Your lordship may not want to say both will apply. That is a good suggestion. It has to be accepted as a guideline, as the Honorable Justice Kohli said. Otherwise, principles analogous thereto will apply, my lord. Prohibited degree is, my lord, a established way. It is a health ground. It is scientifically believed that, my lord, the progeny will be
Health, not only biological.
not only biological.
Prohibited degrees goes beyond biological.
Yes, yes, my lord.
There is an element of social and state prohibition.
But they are justifiable, may not apply across the board. I am only saying how to apply it to this spouse category, which your lordship will now add in. Principles analogous thereto, my lord. Nobody can say that that can't be extended. My lord, I have dealt with procreation and childbearing, but I have explained it to my lord. Till today, no upper age limit on marriage. Kindly see, my lord, how the first of the judgments in South Africa, the National Coalition for Gay and Lesbian Equality, my lord, put it. Immigration was denied to, my lord, same-sex partners. Fowry came in 2005. Just I'll read page 11. One second, Anuj. From a legal and constitutional point of view, procreative potential is not a defining character.
Adoption denied to same-sex couples who were recognized by law.
Yes.
Fowry was.
Fowry, my lord, was a same-sex marriage.
Same-sex marriage was recognized by law. And yet what was denied was adoption rights.
Very good. Adoption. Well, correct it. My understanding was marriage was confined to the common law definition. The lower court had pronounced.
Same-sex.
Yes. Here, my lord, the case in 99 was under the Aliens Act, immigration was confined to married couples in the heterosexual sense. And the defense was of, my lord, inability to procreate. From a legal and constitutional point of view, procreative potential is not a defining characteristic of conjugal relationship. Such a view would be deeply demeaning to couple, whether married or not, who for whatever reasons are incapable of procreating when they commence such relationship or become so at any time thereafter. Likewise, demeaning to couple who commence such a relationship at an age when they no longer have the desire for sexual relations. It is demeaning to adoptive parents to suggest that their family is any less a family, any less entitled to respect and concern than a family with procreated children. I would even hold it to be demeaning of a couple who voluntarily decide not to have children or sexual relation with one another. My lord, constitutional law is tested on the anvil of a common parlance test, my lord. Our own society, there were times, my lord, when people would repeatedly ask, is there any development on the marital front? Today, my lord, it is considered bad etiquette. And our memory is short. There was a UK prime ministerial candidate, I got the news item, who opposed Theresa May and made a deadly statement that she is no mother. What does she know of administration? She had to withdraw her candidature, my lord. Andrea Leadsom. That is the, my lord, sensitivity with which people have arrived. So this is no issue at all. Surprising that, my lord, it was argued with such vehemence. The candidate withdrew from the party contest before May was elected on this ground, my lord. Andrea Leadsom. It's only illustrative, my lord, as to how society all over has changed. Our society has changed, my lord. My lord, Obergefell on the point that, my lord, you can't see marriage through the narrow lens of procreation.
Asexual.
Yes. My lord, there is one important aspect which page 12, para 26, my lord, is a very important notification of the Central Adoption Resource Authority, which bars single applicant in a live-in relationship from adoption because they are not considered a stable family. So, my lord, it is all the more why, my lord, marriage ought to be permitted. Now, we will proceed on the basis that this is valid because at the moment we are not engaged with the constitutional validity of this. But if this is the view of the union, my lord, it only, my lord, comports with our theory that permit us to marry because then marriage will lend that stability for children to be, my lord, brought up. My lord, Indian Psychiatry Association, similar directions in Navtej was there. We are relying on similar directions, my lord. But what is of great interest is a law in the anvil by the 118th report of, my lord, the Parliamentary Standing Committee, wanting a comprehensive law for everybody, harmonizing Hindu adoption maintenance, juvenile justice, which would cover also the LGBTQ community, my lord. This is a very salutary development by our parliamentary committee. And, my lord, this itself shows that, my lord, adoption is a means of rearing children, even in our country. And the only country, my lord, which collected an empirical data in a court case, which we could locate, was a Hawaiian case, my lord, where on remand from the Supreme Court of Hawaii, they took empirical data and evidence to show and concluded that there is no evidence to show that gay, lesbian, and same-sex couple do not provide children, my lord, the safety, security, and the upbringing they require. My lord, long back in our country, the law was all that is required is the welfare of the child, my lord. If I recollect, it was Annie Besant versus Krishnamurti. If that is applied, my lord, it doesn't matter whether it's a heterosexual couple or a homosexual couple. And all these findings, my lord, based on evidence that they are as well suited as heterosexual couple to bring up children, my lord. So to say, my lord,
And Mr. Vishwanathan, what happens when there's a heterosexual couple and when the child sees domestic violence? will that child grow up in a normal atmosphere
Yes.
of a father becoming an alcoholic, coming home and thrashing the mother every night
Precisely, my lord.
and asking for money for alcohol? I mean, this is so much for heterosexual. There is no there are no absolutes, as I said, even at the risk of getting trolled. But
My lord,
but now this has become the name of the game for judges to confront. Answers to what we say in the court are in the trolls, not in the court.
my lord, think of one more step, my lord. If this is accepted procreation, what if Parliament says that I give only life interest to, my lord, LGBTQ and let it revert to the others, because anyway you are not going to have children. We will now revert it will escheat to government. So we'll keep it in the family by giving you life interest and revert it, because you can't procreate.
Give idea.
No, my lord, I'm saying the consequence, disastrous
No,
consequence of this argument. They are entitled to their security, they are living, they can pass it on to their children, they can will it away. My lord, if this argument is taken to its logical end, you don't procreate, you don't vote, because you're say for the future generation, because you can't procreate.
Then by that token, a law can be made to say that if there is a couple who are 50 years old, they don't have children, they won't have a right to vote. I mean, see, these kind of possibilities are extremes. I mean, we have to keep it within the realms of probability. Let us not, as rhetoric flourish, maybe you can.
But my lord, it will lead to that. Well, tomorrow, if your lordship's imprimatur is obtained, my lord, I'm only saying in the hypothetical scenario, how do we stop this, my lord? Same judgments will be cited. So, and my lord, this couple who are beyond the age, my lord, of producing children, that there is no embargo on marriage has been used as an illustration. And your lordship notice, my lord, I repeat the point, no upper age limit. 18 and 21 are the minimum age limits. Sorry.
Will happen. Law which prohibits, like it had happened in other country. If it prohibits, position will be before the court to be struck
So
down.
eugenics.
Therefore, it is not the other way.
You see, Mr. Vishwanathan, we have looked at societies, we have seen history. Eugenics has been practiced in Germany, in
US, my lord.
The US as well.
Scandinavia.
That Buck versus Bell.
So
Lord-
therefore, see, we have to see within the fabric of our democratic setup and our plural society, whether these are within the realms of possibility. When you make this argument,
My lord, I have, if Chief Justice Holmes
Could say one
could say
generation of
3
imbeciles is
generations of
enough.
imbeciles are enough and uphold sterilization, my lord, Holmes,
but
And-
looking at a different age.
my lord,
When,
and the reality,
at that age, after Plessy,
my lord,
that
and
was an age which lived with Plessy. So we can't just, star everyone in one, this.
my lord,
black or
and,
white.
and the,
You had Dred Scott because it was
my lord, and there is a, sorry, my lord was.
No, no, I'm not saying that.
My lord, is-
Root is not necessary.
It is only an illustrative to show this procreation is presented, my lord, across the world spectrum.
The point is.
My lord, just coming back to that, my lord, there is a study by Adam Cohen in his book Buck versus Bell that it appears the report of that Bell that these are, my lord, Down syndrome people, it was also false. The children have topped the, my lord, the school. The mother, my lord, had done well, but they were all, my lord, sterilized, saying 3 generations of eugenics, of imbeciles are enough. My lord rightly mentioned, my lord. So this is actually the eugenic scenario, but I understand. But I'm saying, my lord, procreation cannot be placed at that pedestal, my lord, that as if the entire institution is for, my lord, procreation. It is in that context, my lord. Yes.
You can't say it can't be, you can say certainly it cannot be
My lord,
placed at that pedestal.
my lord, I'll take it. I'll only put it this much that gay, lesbian, LGBTQ parents are as much qualified to, my lord, rear children, adopt and rear children, my lord, as bring up children, as much as, my lord, the heterosexual parents are. The next point has already
put
been.
it in this way that same-sex couples seek the same benefits of marriage, save and except for procreation.
Yes.
And there are a whole range of benefits which cohabitation and marriage provides, which same-sex couples assert for themselves.
Denied. Family pension, my lord, is an important aspect.
I think the word Mr. Ramachandran put it, it's a gateway. It's a gateway. It opens up so many possibilities.
Very great.
So many
That's the
rights,
correct way
so
to look at
many
it.
entitlements. Those which you can enjoy.
Enjoy.
And those which, of course, you cannot be part of, you don't.
That's correct.
You take it as it is.
But the choice, my lord, should be given. That's what my lord is. The choice should be available. It's up to me to enter, not enter, exit.
Just
I
as
put
in the case of heterosexual couples now, with the spread of education, the pressures of of the modern age, increasingly couples are either childless or single child couples, and therefore you see even populous countries like China now really losing out on the demographic dividend as populations are increasingly becoming elderly. Why? Because the young who are highly educated do not want to have more children. But that's a matter of choice. That's a matter of choice.
Heterosexual marriages doesn't depend upon children.
Correct, my lord.
Right.
Correct. That's as simple as that.
Vishwanathan, this notion, that it's only, the very highly educated or the elitist who want a reduced number of children. You have to only talk to people who work for you in cities like in our city. You talk to people who are close to you and find that, most of them say that we want to have one child. My chauffeur has a daughter.
My lord, a prominent constitutional
A
lawyer.
daughter. So this is now becoming there is
It is on
there's a
record.
degree of awareness, also a feeling that, well, people are moving away from this notion that, well, you must have a boy. That's the spread of education, the impact of education, that you may have just a single child, that you may have a...
It's on record that a prominent constitutional lawyer, my lord, and his wife decided not to have children so that they could dedicate themselves to their my lord, activities and practice society. My lord, sir. I'm just coming to that.
My driver
Only one headline in 15, my lord, the subheading from Barnett, my lord, that memorable line, fundamental rights may not be submitted to vote, they depend on the outcome of no elections. And more felicitously put by my lord Baba Sahib at page 16 bottom, in the context of the Hindu law code, my lord, that I am not, kindly see the last 4 lines of the quotation. I have not the slightest doubt in my mind that the provisions of this bill are in perfect consonance with the conscience of the community. And I therefore no hesitation in putting forth this measure, although it may be a matter of fact that a large majority of our countrymen do not accept it. And my lord, history is recorded that there were several dignitaries who had objection to it. Legal opinions had to be taken. Mr. Satilwat gave an opinion, Lady Krishnamayar gave an opinion about, my lord, signing the bill. I have read somewhere that Babu Rajendra Prasad had reservations on some parts of the bill.
Some part.
And opinions were taken, my lord. Written opinions were taken. There's an opinion published in Statesman Among Jurists of the Lady Krishnamayar. And I think Mr. Satilwat also, my lord, gave an opinion about the binding nature of the aid and advice. So, my lord, views will be there as we transition in society, as we evolve in society, my lord. There will be a large body of status quos. But, my lord, one will only reason it out, my lord, with them. And, my lord, no better way than, my lord, a recent, my lord, verdict which your lordship will ultimately consider and pronounce one way or the other. My lord, rest your
The first bill. It's the Hindu code.
Yeah.
54 was the first one, my lord. There is a
54.
subsequent one also.
Look at it. It was the first attempt to break down barriers. In the endogamous society, even among
Hindus.
Hindus. Apart from that, it gave, of course, a long title says enabling it's a platform for
Yes.
interfaith marriage.
Absolutely.
My lord, women got property rights in the sense of self-acquired. First repetal in section 6 on the death of my lord, the coparcenary.
Right.
Coparcenary came 2005 all over India. Tamil Nadu introduced it, my lord, in 89. But
And Maharashtra.
Karnataka, Maharashtra.
Andhra.
But, my lord, kindly see, my lord, given property rights, except that there has to be a death and then notional partition and a first repetal at that stage. Now they are parts of the coparcenary. And when 23 was deleted in the 2005 Act, of course, we argue, my lord, under the cab rank rule. I argued saying it can't apply to pending suits. Your lordship rejected it in Gokul versus, my lord, Geeta versus Shekhar.
These are statutory interventions.
Interventions. Your lordship said no. 23, which said for a dwelling house partition, a female must tag along a male relative, is per se, my lord, discriminatory. Merely because it was deleted in 2005, I will not say it has no application to pending suits. You may argue that suits crystallized, law crystallized on the date of the suit. My lord, your lordship could skip this portion, my lord, and quickly go over to, my lord, the 18. I am not going to read the 3 pages, my lord, it's carrying coal to Newcastle. My lord,
18.
18 Roman 5, my lord. And I, my lord, find a lot of reverberations in the ratio in the miscegenation, my lord, law. To say that heterosexual marriages are the norm and are foundational to existence of the state rings a similarity to the theoretical underpinnings of the miscegenation statutes, my lord. Just see, my lord, Gibson, which preceded Loving, my lord. Gibson followed Philadelphia, Westchester. Just permit me to read 5 lines, the underlined ones, my lord, to see the similarity, my lord, because these are moments in history which have already passed through, my lord. The question is one of difference, not of superiority or inferiority. Why the Creator made one black and the other white, we do not know. But the fact is apparent, and the races are distinct, each producing its own kind and following the peculiar law of its constitution. Conceding equality with natures as perfect and rights as sacred, yet God has made them dissimilar, with those natural instincts and feelings which He always imparts to His creatures, which He intends that they will not overstep the natural boundaries He has assigned to them. The natural which forbids their intermarriage and that social law amalgamation which leads to a corruption of races is as clearly divine as that which imparted to them different natures. The tendency of intimate social intermixture is to amalgamation contrary to the law of races. The separation of the white and black races upon the surface of the globe is a fact equally apparent. Why this is so, it is not necessary to speculate, but the fact of a distribution of men by race and color is as visible in the providential arrangement of the earth as that of heat and cold. The natural separation of the races is therefore an undeniable fact, and all social organizations which lead to their amalgamation are repugnant to the law of nature. Further down in the underlined portion, it is simply to say that following the order of divine providence, human authority ought not to compel this widely separated race to intermix. Naim followed it. Then came, my lord, loving. But see, my lord, even in loving, what the holding of the court below was para 42. My lord, Lordship may mark PDF in loving, my lord, 1770 in para 42, where it says 1762 volume 4.
1770.
177, 8 pages, my lord, in this volume is the difference. Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with this arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. And my lord, how it was overturned. However, the court emphatically rejected this reasoning and the defenses taken by holding that the miscegenation statute rests solely on the distinction based on race, and that such classification did not amount to accomplishment of a permissible state objective. It further concluded that the denial of freedom of marriage, which is fundamental to a person's existence, would amount to violation of the equality principle. My lord, 1778 and 1779 PDF. My lord, I'll leave it for your lordships to read at leisure. My lord.
See, in the US Supreme Court in 1923, as recent as, of course, this was a few years before Brown, they denied citizenship to Bhagat Singh Thind. Now he claimed, I'm a white. They said, no, you have to be a Caucasian.
Caucus. Yes. Now, my lord, we are, my lord, more emphatic, both in Lata Singh, my lord, Shafin Jan, where, my lord, the Honorable Chief Justice, as your lordship then spoke, and, my lord, Lakshmi Bai, my lord, the Honorable Justice called, emphatic that, my lord, these are now things of the past. And your lordship, my lord, gave a powerful, my lord, opinion. My lord, the Shafin Jan is PDF 1162, that has been read, I think. And Lakshmi Bai, my lord, Chandargi is PDF 740. My lord. I am not, my lord, reading it. My lord, according to me, this is the equivalent of saying separate, almost equal but separate. I can't say equal as they said, but they were just segregating. Here, my lord, almost equal but separate, my lord, completely unacceptable under our, my lord, constitutional scheme. And in that context, my lord, if your lordship over the page sees Plessy, my lord. I've always been curious to read, my lord, Plessy, because Brown, my lord, gets all the attention. Actually, it appears Brown was not the first case. Lord, just see, my lord, page 23 bottom,
Vishwanathan,
para 48.
end of the day, we'll ask him to wrap up.
The Union of India in its counter affidavit for this honorable court has referred to the decision of Navdeep Singh Johar as merely decriminalizing consensual sexual intercourse between persons of the same sex and nothing more. Note para 48, minute, page.
Yes, yes.
Further, the union has referred, fourth line, we refer to the same-sex relationship as unions, which may not be unlawful, but not all these unions can be given the recognition under the institution of marriage. This apart is also stated that the law is neutral and in line with the principle of equality in as much as it equally prevents other heterosexual unions, such as live-in relationship, from being brought into the fold of marriage. Now, my lord, kindly see, my lord, 3 paragraphs in Plessy 24. My lord, this Plessy will be in an additional compilation filed last night, my lord, because in terms of
we look at Plessy, Mr.
Lordship will look at it. Just mark, my lord, para 51, Roman 1, 2, 3, a statute which founds itself on the distinction of humans based on the color of 2 races has no tendency to destroy the legal equality of the 2 races. Laws permitting and even requiring separation of 2 races where they are liable to be brought into contact do not necessarily imply inferiority of either race. Very similar argument which we are advancing. If the civil and political rights of both races are equal, one cannot be inferior to the other civilly or politically. If one race is inferior to the other socially, the Constitution cannot put them on the same plane. My lord, but my lord, hats off to Justice Harlan, 1895, at page 297 of the reports, my lord, in the additional compilation, who was dissenting in Plessy. Harlan held that the spatial neutrality would not save such practice from the full force of the equality jurisprudence.
Interesting detail about Plessy is there also this man had bought a railroad ticket
Yes, my lord.
and he was thrown out. This was in 1893.
Like Gandhi.
Same 1893, Gandhiji was thrown out from the tree.
Port Chef's tea room.
Peter Maritzburg.
Port Chef's tea room. That was, my lord, a graphic visual which stuck, my lord.
Don't Peter Maritzburg.
It is Justice Harlan held that facial 25 top neutrality would not save such practice from full force of the equality jurisprudence. It was opinion that under the guise of equal accommodation, people of color were compelled to travel separately. Further noted that destinies of races were indissolubly linked together, and the state's endorsement of this segregation would be to permit the seeds of race hate to be planted under the sanction of law. Your Lordship, equalizing it, my Lord, will adjust the affairs for future, and everybody, my Lord, would live happily ever after. My Lord, Brown versus Board of Education came down on the separate but equal doctrine, only limited to a situation of public education. But my Lord, there are other situations where separate but equal for health needs and privacy may be acceptable, but not, my Lord, in where the state has no compelling interest. My Lord, I have already, my Lord, my predecessors have already dealt with the over the page, because I want to go to the TG Act part, my Lord. discrimination, education, removal of discrimination, government to formulate welfare measures, non-discrimination, right?
Let's go now to the Transgender Act. I think
Yes,
let's go.
transgender, my lord, page 29, my lord.
We have-
I am leaving the portion on from disgust to humanity, my lord.
No, that's very beautifully put actually in
Yeah,
Matha.
you'll have to read it later.
We'll read it. I already scanned it.
Actually,
when I-
very
when
good.
you were up.
My lord, page 29, my lord, as far as the transgenders are concerned, I want to make it very clear, my lord, all three categories there, my lord, the male manifested, the, my lord, female, and my lord, the undefined, my lord, the third gender, would seek your lordship's indulgence in permitting them to have marriage between, my lord, the categories. That is, male for male, female for female, and trans for trans, my lord, because that part is similar here also. Nalsa judgment, my lord, passages of which I have given at page 33 bottom, my lord, because a large number of relevant passages, because it's a long judgment. Just go to 33, my lord, and mark this footnote so that your lordship may not have to go to any other paragraph.
Para 33 page.
33 footnote 8, my lord. Yeah, is it, my lord?
Yes, Nalsa.
Nalsa, just mark these paragraphs. Recognizes right to marry. That is, my lord, we have quoted that. In between, my lord, a trans man and a trans woman, that can't be denied. But this is one step more. Because, kindly come back to, my lord.
Right.
I know. That is between, irrespective. No, but Nalsa. Nalsa. But I just want to read para 81 so that my proposition is clear. What Nalsa said was, in quotation, which is also para 81, Article 14, 15, 16, 19, and 21 above discussed would indicate do not exclude hijras, transgenders from their ambit. For the Indian law on the whole recognize the paradigm of binary genders of male and female based on one's biological sex. As already indicated, we cannot accept the Corbett principle of biological tests. Rather, we prefer to follow the psyche of the person determining sex and gender and prefer the psychological test instead of the biological test. Binary notion of gender reflects in the Penal Code 1860, for example, 8, 10, etc., and also in the laws related to marriage, adoption, divorce, inheritance, succession, and other welfare legislation like NAREGA 2005, etc. Non-recognition of the identity of hijras, transgenders in the various legislation denies them equal protection of the law, and they face widespread discrimination. Then, my lord, 119 is Honorable Justice Sikri. Therefore, gender identification becomes very essential component which is required for enjoying civil rights by this community. It is only with this recognition that many rights attached to sexual recognition as third gender would be available to this community more meaningfully. Right to vote, right to own property, right to marry, right to claim a formal identity through a passport and a ration card, driver's license, right to education, employment, health, and so on. The 2019 Act, my lord, recognizes right not to be discriminated, recognizes, my lord, in section 4, the right to manifest any gender. In, my lord, section 5 and 6, to be recognized as, my lord, a third gender person. So, my lord, this right to marry is, my lord, inter se, the my lord, transgenders, correct? All the, no, what, how is your understanding?
Sir, it can be any, a
You want to explain. Well, Ms. Tara wants to explain something on 1 minute on this, my lord.
My lord, simply that a trans person has the right to marry a person of choice, irrespective of sexual orientation and gender identity. Simply.
Yeah. And that reiteration, my lord, is sought in the present proceeding. But your lordship may also make a note, my lord, kindly come back to 64 onwards, my lord. Yeah, para 64. Thank you, thank you. My lord,
Please, the
yes,
definition.
63 is the definition. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and include trans man or trans woman, whether or not such person has undergone sex reassignment surgery or hormone therapy. That is optional, that can't be compelled, that can't be determinative, or laser therapy or such other therapy. Person with intersex variations, gender queer, and persons having such socio-cultural identities as Kinir, Hijra, Aravani, and Jokta. My lord, kindly come to 65, my lord, for the proposition. Provisions of the Act are therefore not exhaustive in nature. 20 of the Transgender Act say that the Act is not in derogation, but in addition to any other law in force. There is nothing in the TG Act to suggest that transgender individuals are barred from the institution of marriage. 67, my lord. It cannot be argued by the respondent that is the state that the rights enshrined in the TG Act are the extent of the rights available under Indian law to transgender persons, as this would tantamount to contempt of the expansive formulation of the rights in NALSA. Indeed, the state's argument that TG Act confines and captures the extent of rights available to the transgender community is further challenged by the provisions of other laws which bring intersex variation and other sexual characteristics within its protective ambit. For example, Adoption regulations of 2022, my lord, we have annexed that. Propounded under the Juvenile Justice Act, variations to genitals are classified under special needs, presumably to prevent such children being rejected by prospective adoptive parents on the basis of prejudice. It will be a logical fallacy to argue that those children with variations of sexual characteristics are entitled to the love and care of the family, the same child as an adult be barred from adopting, fostering, or birthing a child within the framework of a stable marital union and giving it necessary care and protection. 70, my lord, this is how the biological men, biological women came in the pleadings. Respectfully submitted, the institution of marriage cannot be prerogative of biological men and biological women alone. In view of Section 4 of the TG Act, read with Section 7 of the TG Act, further it is now well-established concept that gender is distinguishable from sex and gender can be expressed or performed in myriad of ways. When the legislation itself provides for self-perceived gender identity, the state may be stopped from relying on an outmoded formulation of gender based on the presence of certain secondary sexual characteristics. 2C of the Act defines family as a group of people related by blood or marriage or by adoption made in accordance with law. Traditionally, members of the trans community have found love and acceptance from found families or families of choice.
Now, Mr. Vishwanathan, last 2 minutes before you conclude, tell us on reliefs.
Relief,
Just
kindly
formulate
come,
now, that's it.
Kindly come to, my lord. I have written it down, my lord. Kindly come to 39, para 92, my lord.
Just tell us what's your
My lord,
on relief.
since it is a challenge to the validity, and if your lordships find that exclusion of, my lord, couple other than heterosexual couple from the recognition of the status
Will
and
make it invalid.
marriage would make the provision invalid. The only way to save it would be, my lord, to equalize it. And that equalizing principle, my lord, is a device your lordships have adopted in our courts. Kindly see, my lord, the two case laws cited, page para 97 and 98. Vishnu Das Hundumal versus State of MP, followed, my lord, in, I will read para 98. With respect to the concept of reading into the statute, respectfully submitted that the same is now well recognized in our Indian jurisprudence, adopted by the sort in various instances. One such recent decision is Association of Old Settlers of Sikkim. Will not kindly mark, my lord, para 44 at page 335 of Honorable Justice M.R. Shah, and my lord, para 147, 148, 150 of Justice Nagaratna, Honorable Justice Nagaratna at page 378, held that exclusion of old Indian settlers who were permanently settled in Sikkim prior to merger of Sikkim with India on 26/4/75 from the definition of Sikkimis in section 1026 AAA of the Income Tax Act, violative of Article 14. Upon holding the exclusion as unconstitutional, it was ordered that all old Indian settlers were entitled to exemption benefits provided under the said provision in order to sustain the constitutionality of the said provision. So, my lord, Indian settlers who did not give up citizenship were not entered in the Sikkim register. Income Tax Act said all those in the Sikkim register are exempted from income tax. It was argued, my lord, I had the privilege of assisting the court, citing Vishnudas, Handimal and other cases, my lord, including Nakara, that the provision need not be struck down, but the left out categories, my lord, are added to it and equalized. Lordships accepted it. In fact, Honorable Justice Nagaratna laid down and said it is up to Parliament to amend, but all will be entitled to exemption by equalizing it. So if your Lordship apply that, all that is required, my lord, is for the time being to add husband, wife, or spouse. Rest will, my lord, follow. They need to tailor it. Or the Fowry model, my lord.
Thank you, Mr.
Very grateful, my lord. My lord, age, on the age issue, there is a request that in case the Special Marriage Act is to be interpreted, my lord, the default age be kept at 18 for, my lord, the third gender. And so, keeping in view the Indian Majority Act, my lord, so that there is no, my lord, disparity there or a doubt or ambiguity there. It may be said that man and female, there is an age, but for the third gender, it may be kept at the least common denominator of 18, my lord, because it is a right which is recognized. But, my lord, the main point is, if fundamental right is recognized, my lord, legislation will have to be suitably tailored to uphold validity. It's a secular law, there's an obligation to enact, and, my lord, they will have to put in place, my lord, all these issues of whether offences, my lord, will disqualify, what will disqualify. Your Lordship need not, as Honorable Justice Cole raised that point. Once the broad parameters are laid down, my lord, and, my lord, that is our respectful submission, my lord. I am very grateful, my lord. I am grateful. Grateful.
Thari, Anita Shenoy, Dr. Menaka Guruswamy, Saurav Kripal, Vindra Govar, Karuna Nandi, Arundhati Kajju, Raghav Avasti, Shivam Singh, Namit Saxena, and Manu Srinath. We, in any case, will be completing the hearings on this side on Monday. So please, I would suggest that all of you, learned counsel, have a meeting between yourselves, that you ration time between yourselves. It's very difficult for judges to, you know, to curtail anybody and, you know. So between yourselves, if you do it, it becomes much easier for us. So please.
Which is on a very different footing. There is a trans woman who converted to a woman. She entered into formal marriage under Hindu.
So what we'll tell you, the request is this. Since Ms. Geeta Luthra is next,
Yes.
anybody who wants to, we would request Ms. Geeta Luthra to be the nodal senior counsel. Everybody can just have a word with her. Either you do it on a video chat or whatever on Friday or Saturday. That between you, including the interveners, somebody who wants to say something can, and Ms. Luthra will then give us in the morning the order so that we finish so many by lunch and so many in the afternoon.
Very good.
All right. So even the interveners, please do talk to Ms. Geeta Luthra so that she will then distribute time between all of you so that Monday we have to finish this side.
There are few interventions on this side of it.
Oh, yes, of course. Then that you give to Mr. Solicitor's Junior. All right. Thank you.
Grateful.